Artificial intelligence law and regulation in the U.S. Artificial intelligence, AI, is transforming society and the legal landscape at a rapid pace. In this first lecture, we explore how AI is regulated, or not regulated, in the United States, focusing on the current patchwork of laws, emerging state statutes, and efforts by federal agencies. The goal is to provide attorneys a detailed understanding of how U.S. law addresses AI development and use, so they can advise corporate clients and litigate AI-related issues effectively. 1.1 Overview of the AI regulatory landscape. In the United States, there is currently no comprehensive federal legislation dedicated solely to regulating AI. Unlike areas such as data privacy or environmental law, Congress has not passed an AI Act or similar overarching statute. Instead, the U.S. relies on existing laws and agency oversight, alongside emerging state laws. As of 2025, federal lawmakers have proposed numerous AI-related bills and held hearings, but none have become binding law yet. The approach at the federal level has been cautious and piecemeal, emphasizing voluntary guidelines and avoiding strict mandates that might stifle innovation. This means that, for now, companies and lawyers must navigate AI issues primarily under existing legal frameworks. For example, anti-discrimination law for biased AI outcomes, or product liability law if an AI-powered device causes harm, supplemented by new state requirements and agency guidance. At the federal executive level, there have been shifting policies on AI. In late 2022, the White House under President Biden issued a non-binding blueprint for an AI Bill of Rights, outlining principles like preventing algorithmic discrimination and ensuring human oversight. However, this was a guidance document rather than enforceable law. In early 2025, President Trump, following the 2024 election, signaled a more permissive stance on AI regulation, issuing an executive order to remove barriers and promote American AI dominance. That order even rescinded certain policies from the prior administration's approach, reflecting a different regulatory philosophy. The upshot is that the federal executive branch has not yet imposed binding rules on AI developers, instead focusing on high-level principles and, recently, deregulatory moves to encourage innovation. It remains to be seen how this will evolve with changing administrations and whether Congress will eventually enact a unifying federal AI law. 1.2 Existing laws. Applied to AI and agency enforcement. Even without AI-specific statutes, existing federal laws do apply to AI systems in various contexts. For example, sector-specific laws contain provisions that encompass AI applications. The Federal Aviation Administration Authorization Act requires review of AI in aviation safety, and the National Defense Authorization Act directed the Department of Defense to coordinate AI activities. The National AI Initiative Act of 2020 created an office to develop a national AI strategy. These laws don't regulate AI broadly, but they show Congress acknowledging AI in specific domains, like defense and research funding. Additionally, general consumer protection and civil rights laws are being used to police harmful AI uses. The Federal Trade Commission, FTC, has made it clear that if an AI tool is used to deceive consumers or violate existing laws, the FTC will take action. As FTC Chair Lina Khan succinctly stated, using AI tools to trick, mislead, or defraud people is illegal. There is no AI exemption from the laws on the books. This means companies can't hide behind AI. If an AI product generates false advertising or biased decisions, traditional laws like fraud statutes or anti-discrimination laws still apply. Federal agencies are actively enforcing existing law against AI-related misconduct. For instance, in 2023-2024, the FTC launched Operation AI Comply, cracking down on scams that touted AI products or used AI to bolster deceptive schemes. One case involved Do Not Pay, a company marketing an AI lawyer chatbot that falsely promised legal services equivalent to a human attorney. The FTC intervened and obtained a settlement, including fines and required disclosures about the tool's limitations. In another, the FTC sued operators of an online business scheme that claimed its AI tools would generate passive income, alleging it defrauded consumers. These actions reinforce that the FTC will use its broad consumer protection mandate to address AI-driven deception or unsubstantiated AI marketing claims, treating them as unfair or deceptive practices under the FTC Act. Beyond the FTC, other regulators have similarly warned that AI must comply with existing laws. The Equal Employment Opportunity Commission, EEOC, for example, has cautioned that employers who use AI resume screening or hiring tools could violate anti-discrimination laws if those tools have disparate impacts on protected groups. The Food and Drug Administration, FDA, has issued guidelines for AI in medical devices, requiring evidence of safety and effectiveness. Even the Federal Communications Commission, FCC, has stated that using AI to generate robocalls or voice messages falls under its Telephone Consumer Protection Act rules. In sum, regulatory agencies are actively interpreting and extending current laws to cover AI, a phenomenon often described as regulation by enforcement. Attorneys advising corporate clients must ensure that AI products and services are compliant with the patchwork of applicable laws: privacy, consumer protection, product liability, etc., and be prepared for agencies to investigate novel AI-related harms under traditional legal theories. 1.3 State AI legislation, Colorado's pioneering law, and others. With federal legislation lagging, state governments have begun to fill the gap. A major development occurred in 2024 when Colorado enacted the nation's first comprehensive AI law, the Colorado AI Act, aimed at high-risk AI systems. This law is significant and likely to serve as a template for other states. The Colorado AI Act imposes duties on both AI developers and deployers. It defines high-risk AI systems as automated systems that make or aid decisions with significant effects on consumers' lives. For example, decisions related to education, employment, essential services, healthcare, housing, insurance, or legal services. For such systems, the law requires that developers and users exercise reasonable care to avoid unlawful discrimination and biases. In practical terms, companies deploying AI in those sensitive areas will need to conduct bias testing, document their algorithms' design, and possibly provide impact assessments. Notably, Colorado's law has no minimum revenue threshold. It applies to any entity deploying high-risk AI in Colorado, big or small. The act will take effect in 2026, giving organizations time to prepare compliance programs. Colorado's initiative has spurred similar legislative efforts in other states. By 2025, states including Connecticut, Massachusetts, New York, New Mexico, and Virginia were considering bills closely modeled on the Colorado AI Act. These proposals generally aim to mitigate AI bias and ensure transparency for automated decision-making. For example, many would require notices to consumers when AI is used in making significant decisions about them, and allow consumers to request human review. The trend suggests that in the absence of federal preemption, the U.S. may see a patchwork of state AI regulations, each with its own nuances, but sharing core principles of bias prevention and accountability. California has been particularly active in AI legislation. In 2024, California enacted a suite of AI-related laws targeting specific issues. One notable example is the California AI Transparency Act, effective January 1, 2026, which will require large public-facing AI systems, those with 1 million-plus users in California, to disclose when content is AI-generated or AI-modified. This law mandates AI developers to implement detection and disclosure mechanisms, for instance, tagging AI-generated images or text, and even sets up a state licensing framework for compliant AI systems. Violations can incur penalties of $5,000 per violation per day, creating a strong incentive for compliance. California also passed the Digital Replica Act, which gives individuals and deceased celebrities' estates a cause of action if their likeness or voice is digitally recreated by AI without consent. This law was inspired by concerns over deepfakes and unauthorized AI avatars of real people, especially in entertainment. Tennessee passed a similar law called the Elvis Act, protecting a person's name, voice, image from AI mimicry without permission. Another California measure, the Generative AI Training Data Transparency Act, will compel AI developers to publish summaries of the datasets used to train their AI models. This is aimed at shedding light on what data, and whose data, is being consumed to create powerful AI tools, including whether copyrighted content or personal information is in the mix. Although these California laws primarily affect companies operating or offering AI services in that state, given California's market size, they effectively set standards that many nationwide companies will follow to avoid being shut out of California. Utah also grabbed attention by enacting the Utah Gen AI Disclosure Act in 2024. This law requires any business or professional communicating with a consumer in Utah using a generative AI, for example, an AI chatbot responding to customer inquiries, to disclose that the communication is AI-generated. Importantly, for licensed professions like lawyers or doctors, the law mandates a prominent disclosure at the start of any communication if AI is being used, regardless of whether the consumer asks. This means, for instance, a law firm in Utah using an AI system to draft client emails or answer questions would have to clearly inform the client upfront that the content was produced by AI. Non-regulated businesses have a slightly lesser duty. They must disclose only if the consumer inquires, a reactive obligation. Failure to disclose can result in fines up to $2,500 per violation. This Utah law underscores a growing legislative concern, ensuring that people know when they're interacting with AI rather than a human. It's also a preview of how lawyers themselves may be directly regulated in their use of AI by state professional rules or laws, a theme we'll explore in the Legal Ethics lecture. In total, more than 40 AI-related bills were introduced across states in 2023, and by the end of 2024, at least a couple of states, such as Connecticut and Texas, had enacted laws establishing state AI working groups or task forces. These initial laws often stop short of imposing substantive rules on private businesses, instead focusing on studying AI use in government or setting up committees to recommend future regulations. However, the trajectory is clear. Unless federal law intervenes, we can expect a growing patchwork of state AI regulations addressing everything from AI transparency, bias, consumer notice, to specific applications like deepfakes or automated hiring tools. Corporate attorneys will need to monitor the states in which their clients operate for compliance obligations, and litigators should be prepared for new types of claims, e.g., a cause of action under a state's Digital Replica Act, or an enforcement action by a state attorney general under an AI law. 1.4 Key takeaways for lawyers: compliance and risk management. Given this complex landscape, what should lawyers, especially corporate counsel and litigators, be mindful of regarding AI? No AI law. Vacuum. Just because Congress hasn't passed an AI Act doesn't mean AI is unregulated. Existing laws broadly cover many AI impacts. For example, if an AI tool makes lending decisions, fair lending laws, like the Equal Credit Opportunity Act, still apply. If AI software is faulty and causes injury, product liability and negligence theories can be used in litigation. Attorneys should dispel any notion held by clients that AI isn't regulated at all. In fact, the FTC and other agencies are watching AI closely and have shown willingness to act. The absence of a single federal AI law means lawyers must map AI issues to existing legal doctrines, a challenging but critical exercise. State-by-state compliance. Companies deploying AI nationwide will face differing state requirements. A corporate lawyer should track developments such as Colorado's AI Act, bias and risk mitigation for high-impact AI, California's transparency and data disclosure rules, and others. Compliance may involve implementing new policies, e.g., adding AI-generated content labels to outputs shown to California users, conducting annual bias audits of algorithms used in hiring in a state that mandates it, or providing notices to individuals when an automated decision affects them. Some states are considering such notice and opt-out rights. It will be important to integrate these requirements into the company's operations early, as these laws often allow enforcement by state regulators or even private lawsuits. Agency guidance and self-regulation encourage clients to follow best practices and frameworks even when not strictly required by law. The White House's AI Bill of Rights, while not binding, articulates sound principles like transparency, bias reduction, and human fallback options that can help avoid legal issues. Likewise, a group of leading AI companies voluntarily committed to certain safety and transparency measures in 2023. If your corporate client is deploying AI systems, adopting similar measures, internal testing, risk assessments, documentation of training data sources, etc., not only prepares them for possible future regulations, but also provides a defensive posture if something goes awry. In litigation, evidence that a company followed industry best practices for AI governance could be persuasive in showing they weren't negligent. Litigation readiness. For litigators, be aware that AI-related disputes are already reaching courts. We're seeing cases like class action lawsuits by artists and authors, claiming AI companies infringe their copyrights by using their works as training data. We also anticipate product liability suits. For example, if an autonomous vehicle's AI malfunctions, or if a medical AI tool gives a faulty recommendation causing harm. Lawyers should start developing expertise in technical aspects of AI, how algorithms work, what data they use, to better handle evidence and expert witnesses in such cases. Additionally, new state causes of action, like the AI digital replica claims in California, Tennessee, create fresh avenues for civil litigation if someone's likeness is misused by AI. Both plaintiffs and defense counsel will need to stay updated as case law develops around these new statutes. Ethical and reputational risks. Apart from formal laws, advise clients on the ethical use of AI. AI systems can inadvertently produce biased or unfair outcomes, e.g. an AI HR tool disfavoring certain demographics. The legal risk is not only enforcement or lawsuits, but also reputational damage and erosion of customer trust. Establishing internal AI ethics committees or review boards is a step some companies are taking. As counsel, you might be asked to sit on or advise such committees to ensure that the company's AI deployment aligns with both legal requirements and societal expectations. In conclusion, U.S. AI law is rapidly evolving. The current environment demands that attorneys be vigilant and proactive, anticipating regulatory trends, ensuring compliance with a patchwork of rules, and being ready to litigate novel issues. AI technology may be new, but the fundamental lawyer's task remains. Protect your client's interests by applying existing law to new facts and shape emerging law through informed advocacy. With a solid grasp of AI law developments, you will be equipped to do exactly that in this dynamic field. Intellectual property law in the technology era. Intellectual property, IP law, is at the heart of the tech industry. It protects innovations, creative works, brands, and secret know-how that drive modern businesses. In this lecture, we provide an extremely detailed overview of IP law with a focus on recent developments relevant to technology and AI. We will cover copyright, patent, trademark, and trade secret issues, highlighting how emerging technologies are challenging traditional IP concepts. This lecture is designed for both corporate attorneys, who might draft tech licensing deals or advise on IP strategy, and litigators, who may handle IP disputes, to ensure you're up to date on everything you need to know in the IP arena. 2.1 Copyright Law. Emerging challenges with AI and digital media. Copyright protects original works of authorship, like software code, literature, art, music, against unauthorized copying. In recent years, copyright law has grappled with technological developments, from software and digital content to AI-generated works. Key points and updates include human authorship requirement. U.S. copyright law has long held that only works created by human authors qualify for protection. This principle has come into sharp focus with AI-generated content. The U.S. Copyright Office issued guidance in 2023 reaffirming that purely AI-created works, with no creative input from a human, are not copyrightable because they lack the required human authorship. For example, if an AI image generator produces a painting with minimal human direction, that painting may not be eligible for copyright. A concrete case. Dr. Stephen Thaler attempted to register an image generated by his AI system with no human artist. The Copyright Office rejected it, and a federal court agreed that under existing law, a non-human cannot be an author. Similarly, the famous 2018 monkey selfie case, where a monkey took a photo, established that animals can't hold copyright. By analogy, AI, as a non-human entity, cannot either. Practical impact. Companies using AI to create content, art, writing, etc., should be aware they might not own a protectable copyright in purely AI-produced material. As a lawyer, you might need to advise clients to have a human exercise creative control or make significant modifications to AI outputs to secure copyright protection. AI and copyright infringement. A hotly contested issue is whether training an AI on copyrighted data or an AI's outputs can infringe copyrights. In early 2023, a landmark class action lawsuit, Anderson vs. Stability AI, was filed by artists against the makers of AI art tools, like Stable Diffusion and Midjourney. The artists allege that the AI developers copied billions of images, including the artists' works, without permission to train their models, effectively creating an unwarranted database of protected works. In late 2023, a federal judge allowed key parts of this case to proceed. Notably, the claim that using copyrighted images in AI training could violate the author's reproduction rights was deemed plausible. However, the judge was skeptical that the AI's output images themselves infringed unless they are substantially similar to specific training images. This is an evolving area, no final ruling yet, but it raises novel questions. Is AI training fair use? Does the creation of a model embed copies of training data? As counsel, if your client is developing AI models or using third-party AI services, you should track these cases closely. Risk mitigation. We're seeing companies implement data provenance measures, using only licensed or public domain training data, or allowing artists to opt out, to reduce litigation risk. Fair use and transformative works. Courts continue to refine how fair use applies, especially with new forms of digital creativity. A major Supreme Court decision, Andy Warhol Foundation vs. Goldsmith, 2023, clarified the limits of the transformative use doctrine in copyright fair use. Warhol had made a silkscreen portrait of Prince based on Lynn Goldsmith's photo. The question was whether Warhol's adaptation was a fair use or infringement. The Supreme Court ruled that Warhol's work was not fair use when it was later licensed to a magazine, because it served the same purpose as the original photo, both used as illustrations of Prince in a magazine, and was for commercial use. The court emphasized that minor stylistic alterations are insufficient if the new work doesn't have a truly distinct purpose or message, especially in a commercial context. This 7-2 decision reaffirms that simply adding a new aesthetic or some changes to a work isn't automatically transformative. One must consider the use's purpose and market. For tech attorneys, this is relevant for things like AI tools that remix or filter images, music. An AI that applies an art filter to photos, for instance, might not create a fair use if the output competes in the same market as the original image. Caution clients that commercial derivatives of existing content, even if AI-assisted, can be infringing unless they truly serve a new purpose or commentary. After Warhol, lower courts are scrutinizing fair use more closely. So reliance on fair use as a defense for tech uses of content, like training data use or user-generated remixes on platforms, is not a sure bet and should be carefully evaluated. Software and APIs. Software code has been protected by copyright for decades, but with limitations. A big recent development was Google vs. Oracle, 2021, where the Supreme Court held that Google's copying of certain Java API code was fair use because Google only took what was needed to allow programmers to use their familiar calls in a new context, Android, a transformative purpose, helping developers, and not substituting Oracle's product. That case underscored that functional code, especially APIs, gets a thinner scope of protection. Companies should still license code or use open source appropriately, but courts might allow more leeway for reuse of interfaces under fair use. However, Wholesale copying of code, including by AI coding assistants, can still infringe. There's an ongoing class action against GitHub's Copilot, an AI coding tool, claiming it regurgitated licensed open-source code without attribution. Advise developers using AI coding tools to review outputs for any large verbatim segments that might come from copyrighted training data. It's both an IP issue and a compliance with open-source licenses issue. Media and entertainment, NFTs and streaming. The tech boom gave rise to new exploitation of content like NFTs, non-fungible tokens. While an NFT is essentially a token representing a digital asset, often art or music, it doesn't automatically convey copyright. We saw litigation such as Hermes versus Rothschild, Meta Birkin NFT case, where an artist's sale of NFTs depicting Hermes Birkin bags was found to infringe Hermes trademarks. That blends into trademark law, discussed below, but also raised copyright questions on whether creating a digital image of a bag design is an infringing derivative. The key point: existing IP laws apply in virtual spaces. Selling an NFT of someone else's artwork is no different than selling an unauthorized print in terms of copyright violation. As attorneys, when dealing with NFT projects or any digital content distribution, like streaming, ensure contracts clearly address IP ownership and rights. On streaming, the music industry has been active in enforcing rights, including regarding AI-generated music mimicking artists' voices, deepfake songs. While there isn't a specific law for that yet, copyright and right of publicity provide tools to combat unauthorized AI music. For example, if an AI generates a song in the style of The Weeknd and uses a vocal model of him, the sound recording and composition could be infringing if they substantially copy existing elements, and his voice timbre might invoke publicity rights. These are cutting-edge issues with no definitive rulings yet, but they illustrate how IP law is straining to cover AI's ability to mimic and generate creative works. Practical tips: corporate lawyers negotiating tech transactions should pay attention to IP representations and warranties. For instance, if a vendor provides AI-generated content, does the contract warrant that the content doesn't infringe others' IP? Because if the AI was trained on copyrighted material without permission, the output might carry risks. Litigators in IP cases must be prepared to educate courts on how AI processes work, to assess substantial similarity or copying. It's wise to involve experts who can analyze whether an AI output contains traces of training data. We are truly in a new era where IP law and AI intersect, and staying informed on court decisions, like the Stability AI case or the Warhol precedent on fair use, is essential for providing sound legal advice. 2.2 Patent Law: Protecting and Patenting Innovation. In AI patent law, grants inventors exclusive rights to new, useful, and non-obvious inventions, typically for 20 years. In the tech field, patents cover things like software algorithms, computer hardware, and biotech innovations. Several noteworthy points for corporate and litigation attorneys. Patentability of software and AI innovations. The U.S. has grappled with the patent eligibility of software and abstract ideas. The Supreme Court's Alice Corpters v. CLS Bank 2014 decision set a strict test that abstract ideas, like an algorithm or business method, are not patentable unless there's an inventive concept that transforms them into a patent-eligible application. Many software patents have been invalidated under Alice. However, AI-related inventions can still be patented if claimed correctly, usually by emphasizing a specific technical improvement. For example, a novel neural network architecture that achieves a new kind of data compression might be patentable, whereas just applying generic AI to a normal task might be seen as abstract. Corporate patent counsel should draft AI patent claims with an eye to highlighting concrete technical solutions, not just do it with AI approaches. AI as inventor? A headline-making development was the question of whether an AI itself can be an inventor on a patent. Multiple patent offices worldwide wrestled with applications listing Daebus, an AI system, as the sole inventor, with the human submitter, Dr. Thaler, asserting he didn't invent the products, the AI did. In the US, the answer has been firm. Inventors must be human beings under U.S. patent law. In 2022, the Federal Circuit ruled in Thaler v. Vidal that the Patent Act's term inventor means an individual human, so an AI cannot be named. Legal ethics and professional responsibility in the digital age. The practice of law itself is being transformed by technology, from using AI in legal research to storing client data in the cloud. This lecture focuses on legal ethics in the modern era, covering how technology, especially AI, intersects with attorneys' professional responsibilities. We will cover rules and guidance on competence, confidentiality, candor, communication, and supervision as they relate to technology use, with a particular spotlight on the ethical implications of lawyers using generative AI tools. By the end, corporate counsel, litigators, and all attorneys should understand their duties in a high-tech practice and be equipped to avoid ethical pitfalls. 3.1. The duty of technological competence. Competence isn't a new concept. ABA model. Rule 1.1 requires lawyers to provide competent representation, meaning having the legal knowledge and skill reasonably necessary. What has evolved is the recognition that competence now includes understanding technology. Comment 8 to Rule 1.1, added in 2012, explicitly states lawyers should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. As of 2025, the majority of U.S. states, over 40, have adopted this duty of technology competence in their own ethics rules. In practical terms, this means lawyers must understand the tools they use, or that are commonly used in practice, e.g., e-discovery software, encryption for communications, AI research tools, at least enough to use them effectively and safely. If a lawyer is ignorant of basic tech, like how to search emails for discovery, or how metadata works in documents, that could be considered a competence issue. Some state bar disciplinary cases have indeed cited lawyers for failing to e-file properly or not safeguarding client e-data. Generative AI tools. With the rise of AI like ChatGPT, the duty of competence implies that a lawyer should know the risks and limitations of such tools before using them in practice. For instance, large language model AIs can hallucinate, making up fake information, which poses obvious risks if a lawyer relies on them for legal research or drafting. A competent lawyer cannot just accept AI output uncritically. They should verify any case citations or statements of law that an AI provides. Indeed, an infamous incident in 2023 involved two New York attorneys who filed a brief that cited non-existent cases generated by ChatGPT. The attorneys admitted they didn't know the AI could fabricate. The court sanctioned them for violating their duty of candor and failing in basic research diligence. The lesson: competence in 2025 means if you use AI, use it wisely. Understand that it's a legal assistant tool, not a source of truth, and always apply your own legal judgment and fact-checking. Continuing education. Many jurisdictions now mandate CLE hours on technology or cybersecurity. Even where not mandatory, it's strongly advised that lawyers proactively learn about new tech relevant to their practice. For example, an M&A lawyer should know the basics of data privacy laws because client deals involve personal data. A trial lawyer should know about deepfakes and social media evidence, etc. The ethics guidance suggests lawyers should attend CLEs, webinars, read up. Basically, make an ongoing effort to stay current. If you feel out of depth technically, you have a duty to either acquire the necessary understanding or associate with someone who has it, perhaps bringing in a tech-competent co-counsel or consultant. 3.2. Confidentiality and cybersecurity. Protecting client information. Confidentiality, Model Rule 1.6, is a core duty. A lawyer must not reveal any information relating to the representation of a client unless an exception applies or the client consents. In the digital context, this rule has huge implications for how lawyers handle electronic data and communications. Using cloud services. Many law firms store client files on cloud platforms or use cloud-based email. The consensus of ethics opinions ABA, and states, is that this is permissible so long as the lawyer exercises due care, meaning you must vet the provider's security, use strong passwords, enable encryption, etc. The ABA Formal Opinion 477R 2017 suggested that for highly sensitive information, lawyers should consider encryption for email or using more secure communication methods. Some state bars even say not using encryption for particularly sensitive communications could be a violation of 1.6 if it results in exposure of client secrets. Rule 1.6 doesn't explicitly mention cybersecurity, but it implicitly requires lawyers to take reasonable efforts to prevent unauthorized access to client data. What's reasonable evolves with technology. Today, it likely includes basics like using VPNs on public Wi-Fi, keeping software updated to patch vulnerabilities, having antivirus, and training staff to avoid phishing. The ABA has also stressed that law firms should have an incident response plan for data breaches. See ABA Formal Opinion 483. If a breach happens, lawyers have duties to inform clients in some situations. ABA 483 says, if it's a material data breach involving client info, you generally need to notify the client and explain what happened and how you'll remediate. Generative AI and confidentiality. A major issue of 2023 to 2025 is lawyers or staff plugging client information into AI tools like ChatGPT. These tools often operate in the cloud and may use the input data to further train the model, unless you have a paid plan with privacy assurances. Inputting confidential client data into a public AI service could be a breach of confidentiality. The ABA's Formal Opinion 512, July 2024, explicitly warns that using generative AI must be consistent with Rule 1.6, meaning lawyers must not disclose client information unless they're confident the AI tool will keep it secure and not disseminate it. That might require obtaining clients' informed consent if, say, you want to use a translation AI on a sensitive document. As a safe practice, many firms now ban or restrict using free AI tools with any confidential text. If using AI, opt for solutions that promise not to retain or share inputs, or use on-premise AI models that don't send data out. Attorney-client privilege. Waiver. Beyond rule. 1.6. Be mindful that disclosing info to certain tech providers might risk privilege. Generally, if you use a third-party service like an e-discovery vendor or cloud host, privilege isn't waived as long as they are serving as an agent of the lawyer and have confidentiality agreements. But be cautious about web-based tools with unknown operators. A court might find that putting client info into an AI chatbot that shares data widely is more like publishing it than keeping it within the attorney-client circle, thus waiving privilege. Remote work and devices. The pandemic made remote hybrid work common. Legal ethics bodies responded by stressing that whether working in the office or at home, lawyers must ensure confidentiality. This includes physical security, no sensitive discussions where Alexa or family can overhear, lock your screen, use shred bins even at home, and digital, secure home Wi-Fi, etc. Model. Rule 1.6's duty to safeguard information doesn't take a break because you're at a coffee shop, so avoid using unsecured networks, or, if you must, use a VPN. Additionally, Rule 5.1/5.3 on supervision means partners must ensure their teams, including non-lawyer staff, are trained on these measures. 3.3 Duty of Supervision and AI Assistance. Model. Rule 5.3, Responsibilities regarding non-lawyer assistance, has taken on new resonance with AI. Traditionally, this rule meant if you use paralegals, investigators, or outsource work, you must supervise them and ensure they comport with ethical obligations. The ABA has clarified that AI tools can be seen as a form of non-lawyer assistance. In 2012, Rule 5.3's title was even changed from assistance to assistance, implicitly covering technology. This means a lawyer using an AI tool must supervise its output, similar to how they'd supervise a junior attorney or paralegal. The lawyer cannot delegate responsibility entirely. For example, if an AI drafts a contract, the lawyer must thoroughly review it to ensure it's accurate, legally sufficient, and tailored to the client, essentially supervising the AI's work. If the AI's draft had a clause that is problematic, the lawyer will be on the hook for any consequences if they didn't catch it. An illustration of this: after the ChatGPT fake case citations fiasco, some courts, like a federal judge in Texas, issued standing orders requiring lawyers to certify that any filing drafted with AI was checked for accuracy by a human. That aligns perfectly with Rule 5.3. The court is basically reminding lawyers, you sign it, you're responsible, whether a human or AI helped prepare it. Additionally, Rule 5.1 and 5.3 imply law firm leaders should implement policies for safe AI use. The ABA Formal Opinion 512 in 2024 urged firms to train lawyers on AI's risks and set guidelines. From a malpractice risk perspective, it's wise too, e.g., instructing attorneys not to paste client secrets into chatbots, as discussed above, or requiring a second lawyer to review AI-generated research memos for errors. 3.4 Candor, Honesty, and AI. Lessons from the ChatGPT Lawyer. Model Rule 3.3 Candor to Tribunal requires lawyers to not knowingly make false statements to courts or submit false evidence. When using tech, especially AI, there's a risk of unintentionally presenting false info if one isn't careful. The Mata v. Avianca incident is now a staple cautionary tale. Attorneys submitted a brief that cited 6 case precedents that simply did not exist, with fake quotes and citations, all generated by ChatGPT. The court was not amused. It found that even if the lawyers didn't intend to deceive, they apparently genuinely believed the AI output was accurate, their actions violated their duty of candor and Rule 11, which in federal court requires due diligence on filings. They were sanctioned with a fine and widespread public embarrassment, with the judge noting that reliance on an unreliable AI without verification is no excuse. Ethically, this underscores: a lawyer must not delegate the critical judgment required in legal practice to a machine. If you haven't read a case yourself, don't cite it. If AI provides a statement of law, cross-check it in actual statutes or treatises. Some courts now demand that attorneys affirm that any AI-provided content has been checked, the Texas judge's order we mentioned, and another judge in Illinois doing similar. Beyond court filings, consider negotiations or communications. If you used AI to draft a factual statement, say summarizing due diligence findings, you must ensure it's truthful. Honesty under Rule 4.1, truthfulness in statements to others, applies in deals as well. An AI might embellish or err, and you can't pass that along unchecked. Another aspect. Model Rule 8.4. C prohibits conduct involving dishonesty, fraud, deceit, or misrepresentation. If a lawyer were to use deep fake technology to gain advantage, imagine altering evidence media or impersonating someone online in an investigation, that could easily run afoul of 8.4c and other rules. Using technology deceptively, e.g., sending a bugged document to an opponent to track when they open it, a real scenario. Some lawyers embedded tracking pixels in emails to opposing counsel, has been deemed unethical by some bar opinions because it's deceitful and violates rights of confidentiality in the other firm. The overarching principle is technology should not be used to do something that, if done by a person overtly, would be unethical. So, impersonation, unauthorized access to data, altering evidence, all forbidden, whether high-tech or low-tech. 3.5 Communication and Client Consent. Model. Rule 1.4, Communication, obligates lawyers to explain matters to clients to permit informed decisions and to consult with clients about how work is done when appropriate. How does this play in with technology? One view, supported by Ethics Opinions and Formal Opinion 512, is that if a lawyer intends to use a generative AI in a way that significantly affects the representation, they may need to inform the client. For example, if a firm plans to use an AI tool to help draft a brief, does the client need to know? The rules aren't explicit here, but consider that clients might have concerns about confidentiality or quality. The ABA Formal Opinion 512 touched on this. It cited Rule 1.4's requirement to reasonably consult with the client about the means to accomplish their objectives. If AI is part of the means, particularly a novel one, the safest practice is transparency. Perhaps we have a software that can first draft contracts using AI, which we'll then refine. It could save time and legal fees. Do you consent to us using that process? This gives the client agency and manages expectations. Some clients, especially corporate ones, are already asking law firms about AI usage policies, wanting to ensure their data isn't inadvertently leaked. So proactively discussing it can build trust. Additionally, fee considerations fall under both communication and Rule 1.5. Fees must be reasonable. If AI significantly cuts the drafting time, there's an ethical question. Can you still bill the client the same hours as you would have without AI? Likely not. Rule 1.5 prohibits unreasonable fees. The ABA Formal Opinion 512 specifically notes that if an AI tool allows a lawyer to do a task in 15 minutes that used to take 2 hours, the lawyer should generally not bill 2 hours, though they can bill the time spent reviewing AI output, of course, and can't bill the client for time learning how to use the AI. In other words, efficiency gains from AI should benefit the client in fee reduction to some extent, not be a hidden profit scheme for lawyers. This ties to honesty as well. Billing for work not actually done by you, or done in far less time, is unethical. Remote communication and virtual practice. Many attorneys now meet clients via Zoom, communicate by text, etc. Rule 1.4 requires prompt and effective communication, so embracing these methods is fine as long as client confidentiality is maintained. But caution! Using texting or messaging apps for client talk might risk confidentiality if devices aren't secure. Also, inform clients of the best ways to reach you securely. Social media and client communications. Attorneys might friend or follow clients on social platforms for more insight, but be mindful not to inadvertently advise them in public comments or breach confidentiality. Also, some attorney-client communications may happen via social media or chat apps. That's still covered by privilege-charmed confidentiality, so treat it with same care, no posting, secure storage, etc. 3.6. Integrity and the evolving legal practice. Maintaining the integrity of the profession in the digital age has new facets. Advertising and solicitation. Online. Attorneys use websites, LinkedIn, even Facebook for marketing. The same rules of truthfulness apply. Rule 7.1. An issue is testimonials and reviews. Lawyers must not pay for false positive reviews or use AI to generate fake testimonials. That would be deceit, under 7.1 and 8.4c. If using an online lead gen service, ensure it doesn't make improper promises on your behalf. Recently, some state bars warned about reputational management firms that post misleading info. Always review your online content. Misuse of social media. Cases abound. Of lawyers getting disciplined for intemperate or unprofessional social media posts, violating 8.4 for conduct, prejudicial to administration of justice, etc. Just because you're behind a screen doesn't remove the obligations of civility and confidentiality. For example, an assistant public defender was disciplined for ranting about a judge on Facebook. Lawyers have been sanctioned for revealing client info in war stories online, even if they thought it was anonymized. The rule of thumb: if you wouldn't shout it in a courtroom or write it in a motion, don't post it publicly. Duty to report and AI misconduct. If you become aware another lawyer is significantly violating ethics using tech, say you discover opposing counsel has doctored evidence digitally, model rule 8.3 may require reporting it to the bar. That duty hasn't changed with tech, but tech might help you discover misconduct, like metadata revealing document tampering. Finally, note that ethics bodies are actively studying these issues. The ABA's Standing Committee on Ethics issued Formal Opinion 512 in 2024, which we've referenced, covering generative AI use. Many states have issued their own opinions on remote work, tech competence, and AI. As part of staying competent, lawyers should keep an eye on new ethics opinions and rules changes. For example, by 2024, California was considering new comment language on AI in its rules, and other bars may follow. In conclusion for ethics, embrace technology carefully and thoughtfully. Always align its use with the timeless principles of our profession. Keep client confidences secret, advocate with honesty, maintain independent judgment. Don't let AI or anyone else supplant it, and ensure you're skilled in the tools of the trade. By doing so, lawyers can harness powerful tech like AI to serve clients better while staying firmly on the right side of ethical obligations, data privacy, and cybersecurity law. Compliance and liability in a data-driven world. In today's digital economy, data is a key asset and a major source of legal risk. This lecture provides a comprehensive overview of U.S. data privacy and cybersecurity laws, with a focus on what corporate lawyers and litigators need to know. We will cover the evolving patchwork of state privacy statutes, important federal regulations, obligations around cybersecurity practices, breach notification duties, and how these impact companies and legal practice. Emphasis is on U.S. law, with brief mention of international contexts like GDPR, where relevant to U.S. companies. This is crucial knowledge for corporate counsel to ensure compliance and avoid enforcement, and litigators who may defend or bring lawsuits after data breaches or privacy violations. 4.1 The U.S. Privacy Law Landscape, State-by-State Patchwork, and no single federal law. Unlike many other countries, the United States does not have a single comprehensive federal consumer data privacy law. Instead, it takes a sectoral and state-driven approach. Here's the current state of play. State comprehensive privacy laws. Starting with California in 2018, the California Consumer Privacy Act, CCPA. A number of U.S. states have enacted broad privacy statutes that give residents rights over their personal data and impose obligations on businesses. As of the end of 2024, comprehensive privacy laws are effective in at least 9 states, including California, Colorado, Connecticut, Utah, Virginia, Texas, Oregon, Florida, and Montana. More are on the way. By 2025, additional laws in Delaware, Iowa, Tennessee, Indiana, etc. will take effect, bringing the total to well over a dozen states with their own privacy regimes. These laws have similarities. Many draw from CCPA or the Virginia law, but also differences in scope and requirements. California, CCPA, CPRA. California's law is the most famous. It gives consumers rights to access their personal information held by businesses, to delete it, with some exceptions, to opt out of its sale, and to not be discriminated against for exercising privacy rights. The CCPA was amended by the California Privacy Rights Act, CPRA, which took effect January 2023, expanding rights, like adding the right to correct data, and to opt out of sharing for cross-context behavioral advertising, and creating a dedicated regulator, the California Privacy Protection Agency, CPPA. Key point: it applies to for-profit businesses doing business in California that meet certain thresholds, e.g. $25 million plus revenue or 100,000 consumers' data. Enforcement is by the California Attorney General and the CPPA. Businesses can face fines up to $2,500 per violation, or $7,500 for intentional violations. Also, CCPA provides a limited private right of action for data breaches, if caused by lack of reasonable security. Corporate counsel must ensure if their company falls under CCPA/CPRA, they have updated privacy policies, have systems to respond to consumer requests within 45 days, and contracts with service providers that include required clauses. Notably, California's regs on automated decision-making and AI use of personal data are under development, so more rules are expected on AI transparency to consumers. Virginia, Colorado, Connecticut, Utah, etc. These states' laws, all effective in 2023, similarly give rights to access, delete, and opt out of certain uses like targeted advertising and sale. They often have exemptions for data already regulated by federal laws, like HIPAA data, GLBA financial data. One difference: some require opt-in consent for sensitive data, e.g., Colorado requires opt-in for processing sensitive personal data like precise geolocation, health, race, ethnicity info. Each has its own nuances in definitions, e.g., what counts as a sale of data. Colorado's law stands out as being more stringent, and with rulemaking by the AG, Colorado's rules cover things like universal opt-out mechanisms. Compliance tip: companies need to chart the overlap and differences. Often they implement a baseline program meeting the strictest common requirements, like an opt-out link for selling sharing data, an internal process for data access requests, and then tweak for outliers. New 2024 laws: Texas, Florida, etc. Texas's Data Privacy and Security Act, effective July 2024, largely mirrors Virginia's, but has an interestingly broad applicability. Consumer includes residents and anyone the business targets in Texas, which might snag some out-of-state companies. Florida's Digital Bill of Rights, also 2024, has some unique provisions, like requiring companies that provide services to minors to get opt-in for selling minors' data. Oregon and Montana likewise join the pack with similar rights. Each of these state laws is enforceable by the state AG. No broad private lawsuit allowed, except California's breach suits. Penalties vary, but typically up to $7,500 per violation, and each affected consumer could be a separate violation. So stakes are high if, say, you ignore opt-out requests systematically. Federal privacy efforts. Congress has considered comprehensive privacy bills, like the American Data Privacy and Protection Act, ADPPA, in 2022, but none have passed. The ADPPA got farther than prior attempts, with bipartisan support, but stalled over issues like preemption of state laws and private right of action. As of 2025, we still do not have a federal privacy law that overrides state laws. This means the patchwork is here to stay for now, and businesses have to comply state by state. One federal development: sector regulators, like the FTC, use their powers, Section 5 of FTC Act Against Unfair Practices, to fill gaps. The FTC has penalized companies for failing to follow their privacy policies or for inadequate data security, LabMD, Wyndham cases. It's also issued guidance like the FTC Privacy Rule for financial institutions under GLBA. More on that soon. Corporate Counsel should consider FTC expectations as effectively a national standard. The FTC expects companies to disclose data practices accurately and to have reasonable security. Failing that, even if no specific law applies, the FTC might act, especially if a data breach harms consumers. Biometric and other specific state laws. Apart from the general privacy laws, note certain states have targeted laws. Illinois Biometric Information Privacy Act, BIPA. This law, effective since 2008, requires companies to obtain informed written consent before collecting biometric identifiers, fingerprints, face scans, etc., and to have a public retention and deletion policy. Uniquely, BIPA has a private right of action with statutory damages, up to $5,000 per intentional violation. This has fueled many class action lawsuits. Companies like Facebook settled a BIPA class action for $650 million over using face recognition on photos without proper consent. Any company using biometrics, time clock fingerprints, facial recognition in apps, etc., must be aware of BIPA and similar laws now in Texas, Washington, and New York City to avoid massive liability. For litigators, BIPA is a booming field. Defenses often argue no harm or attempt to remove to federal court under CAFA, but many cases succeed for plaintiffs given the clear requirements in law. Data broker and marketing laws. States like Vermont and California require data brokers, businesses trading in personal data, not from their own customers, to register and comply with certain security standards. California's new law limits use of data for targeting children and provides an age-appropriate design code. Employee privacy. Some states, e.g., California, include employees in privacy law coverage, meaning employees can request their data, etc. Others exempt HR data for now, but January 1st, 2023, CPRA's moratorium on employee data ended, so California employees now have rights under CPRA similar to consumers. Key takeaways for compliance. Businesses must implement privacy programs. Data mapping, knowing what data you have and where. Privacy notices reflecting required disclosures, like categories of data collected, purposes, rights, etc. Consumer rights handling, a system to intake and fulfill access-deletion requests within statutory timelines. And opt-out mechanisms for selling sharing data, including honoring universal opt-out signals, in states that require it, like via browser privacy signals in California and Colorado. Contracts with third parties should be updated to include required clauses, no retaining or using personal info beyond purposes, etc., effectively treating certain recipients as service providers to avoid being deemed a sale. Corporate counsel should also be mindful of new legislation on the horizon each year. 2023 saw many new state laws, and 2024 to 2025 could add even more. Constant monitoring is part of the job now, or using external compliance tools. From a litigator's perspective, understand that while most of these laws lack private action, plaintiffs find creative ways, e.g. using state unfair competition laws to piggyback a privacy violation, or pursuing data breaches under negligence or contract theories, plus the specific breach statutes or BIPA, where applicable. Standing in federal court after TransUnion LLC versus Ramirez is a hurdle for privacy claims. Courts often say a technical violation with no concrete harm isn't enough for Article 3. But state courts or specific statutes might be friendlier. Knowing the remedies and limitations of each privacy law is crucial in evaluating litigation risk and strategy. 4.2 Federal Sectoral Privacy Laws. While no general federal privacy law exists, sector-specific federal laws loom large. Health data. HIPAA, the Health Insurance Portability and Accountability Act, and its privacy and security rules, regulates protected health information, PHI, held by covered entities, healthcare providers, insurers, clearinghouses, and their business associates. If you represent a healthcare provider or a vendor handling health records, HIPAA dictates strict rules on use disclosure of PHI, mostly requiring patient consent or an applicable exception for treatment, payment, operations, etc. It also has security standards requiring administrative, physical, and technical safeguards for electronic PHI. Breaches of PHI, unauthorized access disclosure, require notification to affected individuals and HHS, and sometimes media, under the HHS Breach Notification Rule. Enforcement. HHS OCR can impose hefty fines, into millions, for violations, and states' AGs can also enforce. Notably, HIPAA does not have a private lawsuit provision, but patients often attempt to sue under state law if their data was breached, though defendants argue HIPAA preempts such claims or that no harm occurred. Corporate counsel must ensure clients have HIPAA compliance programs, including training staff, having proper business associate agreements, BAAs, with vendors, and conducting risk assessments. E-discovery in litigation involving medical info requires redaction or protective orders to avoid HIPAA violations. Financial data, GLBA. The Gramm-Leach-Bliley Act covers financial institutions, banks, investment firms, insurers, and has two main rules. The privacy rule. Institutions must give consumers privacy notices and chance to opt out of sharing their non-public personal info with non-affiliated third parties in certain circumstances. And the safeguards rule requires financial institutions to implement a comprehensive written information security program. The FTC enforces GLBA for entities not regulated by bank agencies. In 2021, the FTC updated the safeguards rule to be more prescriptive, requiring things like encryption of data at rest and in transit, multi-factor authentication for access, periodic assessments, etc. Compliance deadline was mid-2023 for most provisions. If you advise fintech or any company significantly involved in consumer finance, ensure they follow these stricter security mandates. Also note, GLBA has breach notice requirements via banking regulators and some overlaps with state law obligations. Again, no direct private right of action, but regulators, FTC, CFPB, state financial regulators, enforce violations. Children's data. COPPA. The Children's Online Privacy Protection Act imposes requirements on operators of websites or online services directed to children under 13, or that knowingly collect personal info from kids under 13. They must obtain verifiable parental consent before collecting such data. Among other things, post a privacy policy, allow parent review, delete. The FTC actively enforces COPPA. Recent cases involved popular apps and even smart toys. For example, in 2022, the FTC hit Epic Games, Fortnite, with a $275 million fine for COPPA violations and dark pattern issues. If your corporate client runs an online service with possible users under 13, COPPA compliance is a must. Or choose to avoid data collection from kids altogether by age gating. State laws are adding extra layers. E.g., California's Age-Appropriate Design Code, 2024, which requires all online services likely to be accessed by under 18 to default to high privacy settings and consider the best interests of children in design. Education records. FERPA. For schools receiving federal funds, FERPA restricts sharing of students' educational records without consent, typically relevant to school attorneys or edtech vendors, who are often school officials under FERPA via contracts. FERPA is enforced by the Department of Education and can pull funding, though that's rare. They usually require corrective actions. Parents and eligible students have rights to access and request amendment of records. Communications privacy, ECPA, CALIA, etc. The Electronic Communications Privacy Act and Stored Communications Act deals with privacy of electronic communications and government access to them. For civil practice, SCA is sometimes used to claim a violation if someone unauthorized accesses an email account. But it's mostly criminal context. There's also the Telephone Consumer Protection Act, TCPA. Not exactly privacy in data sense, but a consumer protection law restricting robocalls and texts without consent, which has a private right and statutory damages, a fertile ground for class actions if a company blasts texts unlawfully. Corporate counsel should ensure marketing teams comply with TCPA, get express consent for SMS marketing, honor do not call lists, etc. Given time, a brief mention. The FTC Act, Section 5, is a catch-all. The FTC treats failure to adhere to stated privacy policies or inadequate data security as unfair or deceptive acts. They've issued consent orders to companies like Facebook, Google, Wyndham Hotels, etc., over privacy security misrepresentations or lapses. Under these orders, companies must maintain rigorous privacy programs and face fines for any further violations. So even if no specific law covers an issue, say a smart TV listening to conversations unexpectedly, the FTC might act, as they did in the Vizio Smart TV case. International context. Many U.S. companies also have to deal with GDPR in the EU if they offer goods, services to EU residents or monitor their behavior. GDPR is stricter than any U.S. law, requires a legal basis for processing personal data, consent or legitimate interest, etc., grants extensive rights, access, erasure, data portability, mandates data protection officers for some, and cross-border transfer restrictions. Non-compliance can lead to fines up to 4% of global revenue. While a deep dive into GDPR is beyond scope, U.S. counsel working for global companies should flag when GDPR might apply and involve EU counsel to ensure compliance. especially in things like cookie consent, which GDPR and e-privacy directive require, hence those cookie banners everywhere. 4.3 Data Security Obligations and Breach Notification. Cybersecurity law in the U.S. is a combination of statutes, regulations, and common law expectations focusing on safeguarding sensitive data and systems. Key aspects: reasonable security requirement. Many laws impose an obligation to implement reasonable security measures to protect personal data. For example, California's Civil Code 1798.815 requires businesses that own or license personal info of Californians to implement and maintain reasonable security procedures and practices appropriate to the nature of the info. Other states, e.g., Connecticut, Oregon, have similar statutes. While reasonable security isn't precisely defined, industry standards like NIST or ISO frameworks provide guidance. Failing this can not only lead to regulatory action but also be negligence per se in a tort suit potentially. As mentioned, sector laws like HIPAA and GLBA have their own security rules which essentially codify requirements to assess risks and put controls. The FTC has published guides and in consent orders often enumerates what was lacking, e.g., not encrypting sensitive data, not training employees, etc. From these one can glean what the FTC considers reasonable minimums. Data breach notification laws. Every U.S. state, plus D.C., Puerto Rico, etc., has a data breach notification statute. Generally, these laws require that if a company suffers a breach of security that exposes personal information, defined typically as name plus sensitive data like SSN, driver's license number, financial account number, medical or insurance info, etc., sometimes email plus password, then the company must notify the affected individuals, and often state regulators or credit bureaus, within a certain time frame. For example, Florida requires notice to individuals within 30 days of discovery of breach. Colorado has 30 days. Many states say 45 days. Some states impose an outside notification to the state AG if more than a certain number of residents are hit, e.g., 500 in California. Failure to notify can result in AG enforcement and fines. Notably, under these laws, there's typically no private right of action for failing to notify. Enforcement is by AGs. But if people are harmed by a breach, they do sue under negligence or contract, if promises of security were made. Federal breach rules. Besides state laws, specific sectors have breach rules. HIPAA. Notify within 60 days, plus media notice if greater than 500 people in one state, and HHS notice. And Graham-Leach-Bliley. Banks follow OCC-FRB rules, now requiring 36-hour notice to regulators for significant incidents, as of 2022. The SEC in 2023 adopted cybersecurity disclosure rules for public companies. They must disclose any material cybersecurity incident on an 8K within 4 business days of determining materiality, and also include in annual reports a description of their cyber risk management and governance, like what the board and management do to oversee cyber risks. This SEC rule means cybersecurity is now a board-level compliance issue for public companies, and failures could lead to securities law liability if disclosures are misleading or late. Corporate lawyers should work closely with IT and InfoSec to ensure incidents are escalated and assessed for materiality promptly. Litigation from breaches. After a big data breach, e.g., Target 2013, Equifax 2017, Marriott 2018, multiple lawsuits follow. By consumers, class actions. Shareholders, derivative suits claiming directors failed in oversight. Perhaps business partners. Consumers have had mixed success due to standing issues. Some courts require proof of actual identity theft losses. Others allow cases to proceed based on risk of future harm or just violation of privacy. Many companies choose to settle to avoid protracted litigation and PR harm. Derivative suits have sometimes gotten traction, e.g., Target's directors settled derivative claims by agreeing to certain governance measures. Recently, some shareholder suits against SolarWinds, a tech company breach, and against Marriott survived motions to dismiss, indicating courts might expect cyber oversight as part of fiduciary duty. Delaware courts signaled that Caremark duties, oversight, include cybersecurity for companies where that's a critical part of operations. There was a case against the board of a company that had a massive privacy compliance failure. Marchand vs. Barnhill, though that was food safety, but principle extends. Also, in 2023, the SEC charged some companies for misleading disclosures around breaches, and even charged an ex-Uber CISO criminally for covering up a breach. Lawyers must counsel that transparency and prompt action in breaches is crucial. The cover-up is often worse legally than the breach. Ransomware and incident response. A modern plague is ransomware attacks, where criminals encrypt a company's data and demand payment. Legal issues abound. Paying ransom might implicate OFAC sanctions if the hacker is a sanctioned entity. The Treasury Dept has guidelines here. They sometimes sanction hacker groups, making it illegal to pay them without license. Also, paying doesn't absolve you of notification duties if data was exfiltrated. Many attacks steal data too. Part of an incident response plan should involve counsel to maintain privilege in investigations, and quick involvement of law enforcement as needed. Preventive law. Corporate counsel should help implement policies, regular security audits, vendor risk management, since many breaches come through third-party vendors, cyber insurance to mitigate financial hit, and training. Phishing remains the top threat vector, so training employees to spot suspicious emails is key. From an ethical standpoint, tying to Lecture 3, lawyers handling client data also must ensure their own firm's cybersecurity. ABA Formal Opinion 483, 2018 says lawyers have to notify clients of a data breach at the law firm that involves their data. Many states now require tech CLEs on cybersecurity. It's part of being a competent lawyer today. 4.4 Enforcement and Looking Forward. Enforcement of privacy and security laws is intensifying. State AGs have a growing cadre of privacy units. The California CPPA will start bringing actions. It can fine $2,500 per violation, $7,500 if intentional or involving minors' data. The FTC is pushing boundaries, e.g. using the FTC Act to penalize companies for algorithmic misuse. The FTC ordered one company to delete algorithms built on ill-gotten data. The FTC also now has rules against using AI in deceptive ways, like its 2024 rule on fake reviews, including AI-generated ones. The SEC's new rules mean more pressure on companies to be honest about their cyber readiness. One likely development. Federal privacy legislation could eventually come, particularly if a patchwork becomes too burdensome, but perhaps not in the immediate term due to political differences. Instead, we might see federal sector expansions, e.g. a federal law for IoT security. Already there's a patch. Many states have IoT device security laws requiring reasonable security in connected devices sold. Also, states might start enforcing data minimization and AI profiling rules. The California draft regs on automated decision tools hint at U.S. moving a bit towards GDPR's approach on profiling transparency. For litigators, privacy class actions will remain challenging but possible, especially under statutes with statutory damages, BIPA, TCPA, or in state courts. For corporate attorneys, the challenge is ensuring compliance in a moving target environment. Good practice is adopting a global privacy framework, like adhering to principles of transparency, choice, data minimization, security, access, which align with GDPR and most laws. That way, even if laws change, you're largely there. Key practical tips. Always know what personal data your company client is collecting and document the purposes and where it's stored. This data inventory is step 1 for any compliance or breach response. Draft clear privacy notices and keep them updated. Don't promise what you can't deliver. That's how you get an FTC deception charge. Implement a breach response plan. Who to call, forensics, outside counsel, PR, how to contain the incident, how to determine notice obligations, maybe have a matrix by state. Don't forget employee data. Employee privacy lawsuits are rising, e.g., under BIPA or under state wiretap laws if employers monitor employees improperly, like a recent case about keystroke monitoring software raised issues. Consider attorney-client privilege. Involve legal counsel in data security assessments and incident investigations so that findings can be privileged, at least partly, given litigation is common after breaches. Keep an eye on international transfers. The US and EU just implemented the Data Privacy Framework in 2023, replacing Privacy Shield, to allow EU data to US with self-certification and assurances. If your client deals with EU data, consider certifying or using standard contractual clauses. Also, China, India, many countries now have strict data localization or privacy laws. Cross-border companies need multi-jurisdiction strategies. In conclusion, privacy and cybersecurity law is one of the most dynamic fields. Lawyers must stay educated. The fact we have a whole CLE on it highlights that. The cost of getting it wrong includes regulatory fines, lawsuits, reputational harm, and even personal liability in some scenarios, CISO indictments, shareholder suits against officers. But getting it right can also be a competitive advantage. Consumers value privacy. As counsel, our role is to guide companies in ethically and safely handling data, the new oil, in compliance with the mosaic of laws.